And nearly 6 years after the Supreme Court held privacy to be a fundamental right, the Digital Personal Data Protection Bill was tabled in the Parliament today by IT Minister Ashwini Vaishnaw amidst opposition by Congress, TMC and AIMIM. Remember, the bill aims to enforce lawful and fair usage of online personal data. The draft version of the bill was released first by MeitY in November 2022 and it underwent several rounds of consultations. But what is this bill and how does it really impact you and me? Well, remember, the bill will decide and set a regulatory framework for the data-reliant digital economy, which is all set to become a $1 trillion economy by 2030. So, law is crucial to decide how personal data of users is used by corporates, government and other intermediaries, whether inside the country or outside of it. And secondly, India ranked second in the total number of breaches that happened in just 2022 alone. And hence the bill lays down some rights of users over their data, also while specifying strict obligations for data fiduciaries that collect and process personal data at a large scale. So let's now look at some specific areas that the bill looks at. Number one, the definition of personal data. Number two, seeking consent of users before using their data, considering that most companies never ask us before they start tracking us or before they start using our data or even sharing it with third-party providers. And it also allows consent of users to be withdrawn and their data to be erased. Next up, applicability and scope in processing personal data on how data is processed within the territory of India and outside of the country. The bill also lays down stringent obligations for data fiduciaries on how third-party processors are engaged at the time of data collection, and at the same time it's a responsibility of data fiduciary to maintain safeguards so that data breaches and cyber hacks and attacks can be avoided. In fact, in case of children, data fiduciaries must obtain the consent of parents. And most importantly, it allows for the formation of a data protection board to determine non-compliance and imposition of a penalty which could go as high as to 50 crore rupees if the data fiduciary fails to report a data breach to the board and affected individuals. Remember, this bill has been a subject of a lot of debate since it got introduced. In fact, some objections were raised in the Parliament today as well by opposition parties who stated that the bill, number one, violates the basic fundamental right of individuals to privacy, including a dilution of the RTI Act. Number two, the IT Standing Committee's recommendations were not heeded and that it should be sent back for proper examination. Number three, that there is excessive centralization of data. Number four, there is no clarity on compensation on whose personal data has been compromised. Number five, it divides the digital universe into two parts: non-government organizations, which face more penalty, and government, which is exempt from punishment. Number six, that the Data Protection Board would act as a captive entity of the board and not an independent regulation. So those are some of the concerns that were voiced by opposition parties in the Parliament today. Meanwhile, Ashwini Vaishnaw, the IT minister, stating that such a regulation is needed as India moves into a decade, as India tries to strengthen its digital economy, its digital ecosystem, and gives more power in the hands of individual users.